Hi, I'm Anthony Alder from Alder IP, and welcome to another episode in the IP series. Today we're going to be talking about a fairly interesting topic. It's talking about Inventive Step in Australia. When you get a patent, your patent has to meet two basic requirements. It has to be novel and it has to be inventive. Inventive means that it can't be obvious to a person skilled in the art at the time you invented it. If you're thinking about it in a practical sense, novelty means that those things haven't existed all together in one piece. Say, for example, you invent a red car and there were no red cars in the world. That would be novel. If there were red cars in the world, it wouldn't be novel. But if we move on to the inventiveness test and we take our red car example. So say, for example, you invented a yellow car and you only had red cars. Well, it's novel. It might not be inventive though. And the inventiveness is how obvious it is to make it that color. There's a recent court decision in Australia called Elanco Australia Proprietary Limited versus Abbey Australia, and it was in the federal court. Now, this particular case deals with dosaging, and so what dosaging is, particularly pharmaceuticals or veterinary products. In this case, it was a veterinary product. It was a sheep dip that you de-lice your sheep with. What they were saying was the patent was for a particular chemical that was a known chemical, and it had it in a particular dosage range. And what the patent owner said was, if you use it in that particular dosage range, it's much more effective than any other dosaging range. And that's probably correct. And the other thing was they could show that it was novel in that regard, that no one had ever disclosed that before. But what they failed to show was that it was inventive. And the reason why they failed to show it was because a person skilled in the art would read trade journals, see that chemical, and reading the instructions on the chemical would probably come up accidentally with the same dosaging, or it would be obvious to someone to try to do that. And that's really what the test in the Australian Federal Court's getting at, is that, is it obvious to a person skilled in that particular field to try that out, to try that solution? And in this particular case, it was. This particular decision has interesting ramifications for anything in the dosaging field, particularly pharmaceuticals, biotechnology, veterinary products. But it does more broadly as well for things that are even food products. If you have a particular dosaging range, and that is the main thing that you want to protect, you need to be able to show why a person skilled in the art wouldn't ordinarily come up with this solution. You have to show why it goes against the teaching or goes against the grain of everything else that's gone on before. I hope this helps you understand about dosaging and patent claims, and also inventiveness in a general sort of context. If you need any more information about any of these topics, please feel free to contact myself or the team at Alder IP, and we're more than happy to help. Thanks very much.